assuming we want to move right to reports of investigation instead of stipulated,
Probably would make sense.
and to provide a courtesy, are we fine moving Mr. Caber first?
That is up to you. Because
As long as there's no problem from your end as a staff, that's a possibility, but Mr. Chair, your call.
Yeah, let's do that. So let's have we'll hear agenda item 38A first.
Papers on your desk may have a copy of this because a late addition to the agenda.
Oh,
It wasn't on the original agenda. The agenda itself was changed and the document was sent to us from dealing with this issue, as some of you may or may not know.
gotcha. Amber, we got your notes, so just, you can leave when you need to.
And Commissioner Hollister, just for the record, this is not your last meeting. Just so you know.
I will see you on the 28th.
Caber? All right, commissioners, we have Mr. Caber with us. Thank you for being with us, Sheriff Caber. Appreciate it. My name is Sean Lindsay. I'm the chair of the commission, and now's the opportunity to have your matter heard before us. And the way that this will happen procedurally is we're first going to hear from the investigator in this matter, and that's Ms. Myers, and our executive director, Ms. Myers, and then you'll have an opportunity to respond as well. And with that said, Ms. Myers.
thank you. For the record, Susan Myers. So this is an investigation that focused on whether Sheriff Caber violated the conflict of interest and nepotism statutes when on June 12, 2023, he appointed his son Ryan as detective sergeant. And the background is that he was elected in 2017, took office in 2017. At that point, Ryan had already been employed at the sheriff's office. And then in 2018, his other son, Eric, applied to be a corrections officer. So the county put in place a nepotism, a policy 2018-06 to address the supervision issues, which is what our statutes and rules recommend, is have a written policy that provides for delegation so that the public official who has relatives or household members at the agency does not get into a position where they would be making decisions on the appointment or assignments or any matter that could financially impact their relative or household member. So in 2018, the county put this policy into place and everyone operated under it. Ryan Caber received several promotions, reassignments over the course of those years. And in all of those cases, those matters were handled in accordance with the policy. So Captain Bryson or Captain Swan would be the ones to make those determinations, take the employment actions. And as my report says, that policy worked until it didn't, which was June 12th of 2023. On that date, at that point, Ryan had been a detective sergeant. In February, he then moved to being a patrol sergeant so that he could do the K-9 training. And Sheriff Caber, understandably, in looking at the detectives division, as he explained in his interviews, he saw there was a lack of some leadership and supervision. He felt it was important to put Ryan back in the detective sergeant position temporarily so that the 3 detectives that were there would have a resource to provide the necessary supervision. It was the act of making the appointment that created the problem in terms of the ethics statutes. And the statutes at issue are 177 sub 1, and that has two parts. The first part says a public official cannot appoint, promote, demote, basically take an employment action for their relative or household member unless the conflict of interest requirements are satisfied. In this case, there's no information, there's no evidence that the conflict of interest provisions had been satisfied. The second part of subsection 177(1)(b) actually doesn't even include that little exception for conflict of interest. What that says is a public official may not participate in any interview, discussion, debate regarding the employment action for a relative. So we have the conflict of interest not being disclosed. We have the appointment of the relative. Then the third issue is 244.179, which is the direct supervision statute. Public officials are not supposed to directly supervise their relatives or household members. Again, the legislature has put in an exception. It says that a public body can formally adopt a written policy specifying under what circumstances direct supervision is permitted. The policy that the county had was that policy, and it did work, except on June 12th, when Sheriff Caber took his actions, it was not in accordance with that policy. And the act of appointing Ryan to the position, even if it's temporary, is an employment action that a direct supervisor takes, because the decisions were no longer being made by Captain Bryson, they were being made by Sheriff Caber. As his interviews point out, he had a number of very valid reasons to make the decisions he did. The problem is that in doing so on June 12th, those decisions would violate the statute, the ethics statute. By the following June 15th, which, as he has said, is when ethics was first raised, he then did take steps to walk back. He went to Captain Bryson, said, look, I'm stepping out of this, you handle it. The other issue, and Captain Bryson basically said, I didn't feel I had any choice at that point. The other issue here has centered on this 4% clothing allowance. So in order for him to have a conflict of interest, he would be making a decision that would or could have a financial impact on his relative. The county, there is only one detective sergeant position on the detective side. There are patrol sergeants, but this is the only detective sergeant position. Detectives under the contract collective bargaining agreement, the regular detectives get a 4% clothing allowance with their paychecks, but the detective sergeant isn't covered by that agreement. The detective sergeants used to be part of the Teamsters union. The agreement with the Teamsters ended back in 2020, but the county decided that the benefits that would have accrued under those contracts, that union agreement, would continue. So from 2020 to February of 2023, Ryan was in a detective sergeant position and did receive the 4%. When he moved to patrol sergeant and K9, he stopped getting that. He started getting the K9 special pay. But in making the decision to appoint Ryan back to the detective sergeant position, Sheriff Caber would be met with a conflict of interest. There is an argument as to whether it would be a potential versus an actual. Um, that argument centers on, was there an expectation or understanding that the 4% could apply? It had applied up until February. And I think it is reasonable possibility that it would continue to apply once he was back in that position, even in the absence of the contract. So it leads me, based on the information that was available in the investigation, to make a recommendation that we make preliminary findings of violation of one violation of 244-120, failing to disclose his conflict, and then violations of 177 and 179 for making the appointment and not following the county policy that was in place at the time.
And what, thank you. And commissioners, this is the opportunity to ask anything of Executive Director Myers. What realm of violation are we, what consequent world are we living in?
So, in thinking about the penalty matrix, there isn't, I'd have to go through and look where the points happen. Obviously, this didn't take place over a long period of time. There ended up being no actual financial benefit because, in fact, Ryan was put on administrative leave only 10 days in. So there and no change of status form was signed by Captain Bryson. So chances are the penalty matrix may recommend a letter of education.
Okay.
Questions, Chair?
Yeah, go ahead.
This might be a question better for the sheriff, but just in case. You said that when Detective or Sergeant Caber was transferred from patrol to detective, there was a 4% allowance. You know what the allowance was for as a canine officer? I would assume he got some allowance there as well.
So my understanding is he was remaining as a canine officer. The canine officer, it's not an allowance, it's special pay, but they receive 5%, which is some payment for the cost and time spent taking care of the dogs. So my understanding is he was remaining the canine officer and would still receive that. It's simply that the detective sergeant position that he was going to temporarily fill would include the additional 4%.
Thank you. Any other questions for Ms. Myers, commissioners? Seeing none, Sheriff Caber, thank you for being with us. Now's your opportunity to respond.
Thank you, Chairman. I have a written statement. I would probably like to stick with it. With the 3 pending violations pending, I hope you'll give me just a little bit of time to try and go through it. Thank you, Susan, for your introduction. I don't believe you got anything wrong factually. I just disagree that there was a conflict of interest at all, and I think I have reasons to prove that. And without the conflict of interest, everything else should dissolve because that's just the way I see it. So if you will just permit me to go through this, I will try and make it as quick as I can. I've shortened it as best I could, but there's a lot of stuff. And if you followed all of that, you're doing really well because there's so many moving pieces to this that it's taken me this long to really feel like I comprehend it. I'm here before you today because this complaint of 10 months ago needs to be settled, and I believe appearing in person before the commission is the sincerest way to respond to these allegations. As the elected sheriff of an understaffed office, I made a leadership decision in June 2023 in the best interest of the citizens and the sheriff's office employees, and that was called into question. I am more certain now than ever that small county political motivations and aspirations of many individuals mentioned in the staff report played a role in bringing this complaint. I swore an oath when I took office to uphold the Constitution of the laws of this state, and I have done that. As a sheriff in the country, I have a job to do, and I intend to do that job. That is what leadership is to me, regardless of where the chips fall. I have a responsibility to maintain. The responsibilities of a sheriff require hundreds of daily decisions in order to provide the service required by a community, and that is what I was doing that brought me here today. The staff report you received by Susan pertains to whether or not portions of Chapter 244 were violated, and I strongly disagree with her conclusion. I did not violate Chapter 244. In my career, I have interviewed more than 1,000 criminal suspects, and never once did I ask them to admit to something that they did not do. So I'm going to get away from my notes for a second. So because of that, as I looked over a variety of stipulated offers, if you will, that came to me, like if you stipulated to this, this could happen and that sort of a thing, I just could not bring myself to agree with it because I did not believe I violated the statute. And as I continue, I'll be able to tell you why. I was told by an earlier investigator that intent is not considered in the evaluation report, and both investigators indicated that this is a very technical look at the statutes. Appearing before you is the only chance I have to basically state my case and maybe get a little bit more of what really happened out. Whether there was or was not a conflict of interest fully hinges on whether or not Sergeant Caber would have received a pecuniary or financial benefit if he had actually taken over supervision of the criminal division. He never took over supervision. And people will probably disagree with that, but I just checked with him today, even just to make sure I was right, that he never made any assignments as a criminal detective sergeant at all during this short period of time. There are 2 points I'd like to make regarding the conflict of interest claim. The financial benefit or detriment to a relative was not part of any decision I was making. I understand that if an elected official makes a decision that benefits financially a relative, that would be unethical. That did not happen as represented in the report. And I'm glad in the report, like Susan Meyer almost says, it just depends on how you look at it, I think. Despite claims that it may have taken place or could have taken place, the financial benefit, it could have taken place, and that the county paid the sergeant a percentage of clothing allowance in the past are not factually accurate. The current agreement the sergeants have with the county and the one that was in place in 2023 does not require payment of a clothing allowance, period. Now, Human Resources claims that they would have paid him this benefit, so therefore it would have been a financial benefit, is highly suspicious to me because it is not in the agreement. They may have paid it in error in the past, but now if they admit that they didn't actually need to pay it, it would display their error and it would take the wind out of their claim that I was going to provide a financial benefit to a family member. That was not part of any of my decision, by the way. This is the basis for the entire complaint in the first place. Was a family member of mine going to receive a benefit? I do not believe they're being realistic if they claim he would have certainly gotten it, and I'm in record in early emails making certain that I was not providing him any benefit in my decision. In fact, he was always going to be working in uniform as a canine handler, and he wasn't going to be working in plain clothes and therefore needing some sort of clothing benefit. This was I've used the word before, kind of a hybrid decision. This was a temporary thing, and I'll get into that a little bit later. We have a policy that I was following. Number 2, Sergeant Caber never took over supervision of the detective unit. There were no county documents signed. There was no increase in pay. There was no supervision or assignments given out to detectives by him. It just never took place. And since it didn't take place, there was not a conflict of interest or even a potential conflict of interest requiring a public announcement. At best, it could be claimed that I was attempting to make an assignment that could have been a conflict, but it never took place. These are assertions made by myself and attorneys who have provided legal opinion concerning these facts. As I understand it, I simplified it for myself. If there's no financial benefit and no actual move to supervisory position, there's no conflict of interest. It would require a technical review, as I mentioned earlier, and it would be necessary to make this fit into the violations I'm accused of. You would, by taking a hard look at it, examine every word, make some assumptions, believe some half-truths, and then rule out actual events to make it fit. I'm not making any accusations, but I think some of those things took place in this process. In the staff report is a comment that is offensive to me in the way it reads, and I'm not sure Susan Meyer meant it to be. I heard her say it again today, so I don't think she means it to be offensive, but the concept of me trying to walk it back just is not really what happened. It's as if that sounds like I got caught doing something wrong and then I tried to sneak it back somehow. That is not what happened. What occurred, and what has not been recognized properly, is that when it came to my attention the very first time, this is very important to me, the very first time that the proposed action was viewed to be some violation of ethics, I took the appropriate action to correct it immediately. As mentioned before, I don't agree that I attempted anything that was unethical. My decision was driven by operational need and my sworn position as viewed by the person responsible for organizing the work of the sheriff's office, and that is me. The moment I learned it was viewed as a violation of the ethics statutes, I did what I hoped the commission would want any elected official to do, and that is to not follow through with it. I didn't continue. I didn't force the issue. I didn't double down and claim some overriding authority. I removed myself from the process and turned it over within the hour. To me, that's not the same as walking it back. Susan, I'm sorry. If the standard ever becomes that a person, an elected official, can consider making a decision that is potentially unethical, immediately stop what they're planning in the reverse direction the moment they become aware of it, and then still be found guilty of violating the ethics statutes, there will be no end to the number of complaints that you will have to review, I do believe. Your decision today may have a chilling effect on every elected official in the state and will add fuel to those who would like nothing better than to hogtie their political opponents with an ethical complaint. Now, I'm getting closer. Thank you for giving me the time, by the way. In my statements thus far, if I haven't caused you to at least consider there was no conflict of interest and that I took appropriate steps to recuse myself, I doubt that I'll be able to successfully prove to you that I did not directly supervise a family member either, which is one of the other claims there. The assumption is that one word in the statute, appoint, which was brought up by Susan, was violated and constitutes a nepotistic act requiring action by this commission is frustrating to me. I did not directly supervise a relative by attempting to return him to some limited responsibilities for a temporary period, for exigent circumstances, according to our policy, for training and emergency needs of the office. My decision was a sound one, in my opinion. And as things played out, my fears were realized. The sheriff's office lost a senior detective and a level of experience in the unit that helps real victims because I was unable to provide more direct supervision to that division. And the reason it did not take place was because I honored Chapter 244, not because I violated it. I know for sure that the effectiveness of our office has been hindered and compromised in this situation. Regarding the discussion statute, ORS 244-177. This is the statute regarding having discussions, debates, and interviews in violation of the conflict of interest. As stated before, there was no conflict of interest. However, our command staff had discussions every day concerning handling the ever-changing needs of our mandated responsibilities while inadequately staffed. I never swayed anyone to make them do what I wanted done. I see in the staff report there was an allegation I did just that. That is nonsense, and the person making the statement knows it. He is also one of those who has political aspirations, and his complaint fits nicely with this narrative. Sad to me. I never debated or argued in favor of this to get someone to vote along with me. There were no interviews because I was following our policy regarding special assignments. I did explain my decision to my liaison commissioner, and it was for information only. He had no vote for me to sway. At that time, I had not even heard anyone suggest there was an ethical violation. I thought we were discussing whose policies took preeminence, the sheriff's office policies or human resources policies, and it's a debate that goes on to this day. But the discussion was not required because there was no conflict of interest. In closing, I do not believe my actions in June of 2023 were unethical. When I was informed that they could be viewed as unethical, I didn't walk it back as if I was caught doing something wrong. I ended it immediately and recused myself, and hopefully that is what this commission will honor. It never actually took place. The sergeant never received a financial benefit. He never supervised the detectives any more than what any other sergeant or supervisor in my office could have been expected to do. I never directly supervised a family member. I didn't give him a raise, promote him, tell him what shift he was working, authorize his time off. I never evaluated his performance, assigned him an investigation, tell him what uniform he should wear, or anything else related to supervision. If educating elected officials of the ethical pitfalls involved in this chapter is what this commission is looking for, that has been achieved. I can guarantee you. I have lived with it for 10 months. I do not believe I committed conflict of interest. And this issue could have been resolved at the local level, but for the fact that many public officials were involved with their own agendas and refused to discuss or accept a local solution. They could have learned the same things I shared with you today if they were interested, but they told me they were not. They'd already made up their mind when they told me it was going to be viewed as an ethics complaint and they were going to file the complaint. In fact, they doubled down on this and gave me an ultimatum in September, telling me and the community that I had 90 days to leave my elected position as the sheriff, or they would fire 2 family members of mine without cause. To suggest that this complaint isn't being used to weaponize the Ethics Commission to accomplish their goals is disingenuous. Every one of them is currently running for political office or works directly for someone who is, except me. I'm not running for sheriff again, ever. I'm hopeful that you all see that there are many facets to this issue and that I'm trying my best to let you know that a hard technical look at a couple of specific words sprinkled throughout Chapter 244 led to our meeting today. I'm also hopeful that you will look past the conclusion in the staff report and the accompanying finding, and I'm hopeful that you will decide to do what artificial intelligence will never be able to do, and that is to see the heart of the matter and the damage to my community this complaint has caused. Not my decision to temporarily and properly staff the detective division, which is my duty, but the harm to the public's trust of its elected officials as a whole due to the dogmatic and punitive approach taken over the last 10 months. If there is a recommended motion prepared in advance that calls for finding me in violation, I would hope that you would reconsider that motion and make a motion to end this today. Thank you very much. I know I probably went longer than you wanted. I would love to answer questions if you have them.
Thank you. Sheriff Kaber, thank you for being here personally. Commissioners, any questions of Sheriff Kaber? Seeing none, it's now our opportunity to make a decision here. I'm going to speak first, just so that, not because I'm chair, just so you know where, as one of the voting commissioners here, where I'm at on this situation. I really appreciate the thoroughness of Executive Director Myers. She's been very thorough on this, and I've read this thoroughly as well. I've listened thoroughly as well. This is how I see it. One is that I see that there may be some technical violations. And I also see that Sheriff Kaber is not only walking on a high wire, but dancing on a high wire. And if we were to find a technical violation, the likely outcome is a letter of education. And as he said, there has been an education here already. And so in my mind, it comes to, do we want to have a record of a violation or not in this situation? And I'm disinclined to find a violation. Vice Chair Frisco.
Mr. Chair, I'll yield to colleagues if anybody, I don't see a hand up right now, but thank you for your comments. I appreciate those, and I know they're sincere, and I want to echo appreciation for the sheriff for coming all the way from down south to here. Thank you very much for being here today in person. The uneasiness I have about this issue has been replicated for us multiple times over my years here, which is that the opportunity, if that's what it is, it's probably the reverse of that, is to inject ourselves into what I'm going to label, not being a Klamath County resident, as a local political dispute. the character which I won't presume to describe because I'm not there and don't know, but it appears to me that that's the case. And that it could be possible, not saying it is, it could be possible that the Ethics Commission issues are being used there. In that case, we've seen that before. We'll see it again. It's the nature of this business. It's the nature of the legal business, Mr. Chair, sometimes. That gives me substantial uneasiness about proceeding with an investigation, the risks of which it would, once we did that, it would be the finding that a violation has occurred, and that would be used who knows how in Klamath County. That I remain uneasy with that. I'll just stop there and see if my colleagues have any other comments.
Commissioner Thompson.
Thank you, Mr. Chair. I echo the comments of Vice Chair Fiscum. Listening to the staff report and then listening to the sheriff, I'm moved by the fact that it sounds like when he was made aware, the sheriff was made aware that there was an issue, he dealt with the issue. He reversed course in order to avoid even the appearance of a problem. And then I'm also moved by his comments about the fact that he has been educated in this process. So I think if we were going to arrive at letter of education, I think we're already there. And also to echo Vice Chair Fiscum's comments, I'm also very uneasy about wading into an election in Klamath County that it sounds like is heating up. So I would be, I'm disinclined to proceed.
Any other comments, commissioners? Seeing none, I'm prepared to make a motion or receive a motion.
Mr. Chair, I will make a motion, and I believe, just as a quick aside to our executive record, this would be number 7 on the list of motions if I was to move to dismiss.
You're,
Thank you. Just make sure I'm accurate.
yes.
Thank you very much. Mr. Chair, I hereby move that the commission find that the information before the commission is insufficient to infer a violation of ORS 244-179 sub 1, ORS 244.120 sub 2, and ORS 244.177 sub 1, or warrant further investigation, and that this complaint be dismissed.
Commissioners, we have a motion in front of us. I've already spoken to it. Any other comments on the motion before us or any alternative motions? Seeing none, we'll call for the vote.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Sheriff Caber, it's dismissed. It's over.
Thank you, Commission. I hate to be in judgment of anybody. I can't imagine how hard this must be. But thank you.
Thank you.
Thank you for coming up north, and this will be confirmed for you in writing to verify the decision today. So thank you very much.
Thank you.
Right. Thank you.
Yes.
Don't miss your golf appointments.
Thank you.
All right. We are now on to agenda item.
So items 35 to 38 are the investigative reports for Jack Jasperson and Sheila Jasperson. We actually have 4 cases, but I understand they are appearing together.
Believe so. That is my presumption.
So I'm sorry, you said that 35 and 36. Okay, all of those are together then,
Are there 2 separate cases?
Cases, but
but
they're.
can be heard together.
Oh, they'll come online,
Okay,
and they are online.
they online.
Yeah.
Okay. Miss Jasperson, can you hear me? Miss Jasperson or Mr. Jasperson, can you hear me?
They are showing as muted.
Looks like you're muted. Are you unable to mute yourselves and see if we can hear you?
To unmute yourself, you can push *6 on your phone.
We can hear you.
Okay, there we go. And we can hear you. My name is Sean Lindsay. I'm the chair of the commission. Now's the opportunity to have your matters heard before us. And how this will happen is that we're going to hear an investigatory report by
With Monica.
Walker. And then you will have an opportunity to respond. We are on a very long meeting today, so we ask that when you do respond, if you so choose, that you be precise and brief. And with that said, we'll start with Investigator Walker, please.
Thank you, Chair Lindsay and Commissioners. For the record, this is Monica Walker, investigator for the Commission. Agenda items 35 and 36 in your meeting books are investigation reports for ethics cases involving Jack Jasperson, former code enforcement officer and former planning commissioner for the city of Weston, and Sheila Jasperson, former city recorder for the city of Weston. As the nature of the complaint is the same for both respondents, with the chair's permission, I will first provide an overview that pertains to both respondents, but then present separate investigative conclusions for each of the respondents.
Yeah, go ahead.
Thank you. So as far as the overview, the commission found cause and moved these cases to investigation at its November 17th, 2023 meeting. The focus of the investigation was to determine whether there was sufficient evidence to indicate that the Jaspersons violated the use of office and conflict of interest provisions by participating in actions, decisions, or recommendations in their roles as public officials for the city of Weston for personal gain by applying for a fence permit, which is considered a type 1 application, without first having followed all required processes for the approval of a fence permit according to the city ordinances. In addition, whether they did so without proper disclosure of a conflict of interest. Bless you. From the information gathered, the person responsible for reviewing and ensuring that all zoning ordinances and procedural requirements are followed in the issuance of these permits is the city recorder. At the time the application was submitted, Ms. Jasperson was the city recorder for the city of Weston. Thus, Ms. Jasperson was responsible for determining whether the permit request complied with all application and zoning code requirements, whether additional consulting fees should have been assessed, or if any surveys were required. The city's application form states that for a fence application permit and site plan to be accepted, the application materials must include certain documentation. The application submitted was missing much of the documentation required to make a determination on the approval of a type 1 application for a fence permit. Ms. Jasperson, however, accepted and approved the application and issued the fence permit. So in the case of Jack Jasperson, the documentation gathered does not indicate that Mr. Jasperson used his knowledge of the city standards and ordinances to submit an incorrect and incomplete application form. Further, there is no information to support that Jack Jasperson acted in his official capacity and used his position as code enforcement officer or planning commissioner to receive an advantage over any member of the general public in making application for a fence permit. Thus, it does not appear that Jack Jasperson engaged in a prohibited use of position, nor does it appear that he was placed in a position to take any actions or make any decisions or recommendations in either of his official capacities that would require him to disclose a conflict of interest. Therefore, the report in your meeting books recommends dismissal of the complaint for Mr. Jasperson. In the case of Sheila Jasperson, the documentation gathered indicates that Ms. Jasperson did not require that the application include a survey or a letter of agreement from neighboring property owners or other documentation that demonstrated that the proposed fence would be located on or within the property owned by the applicant, in this case, the Jaspersons, as required under the zoning code. Nor did Ms. Jasperson require any additional consulting or surveying of her fence permit application. Thus, there appears to be sufficient evidence that Ms. Jasperson used her official position by approving her and her husband's fence permit application without having followed all appropriate procedures for the approval and issuance of a fence permit. By using her official position to process her own fence permit, Ms. Jasperson appears to have provided a financial benefit to herself and her husband in terms of increased property value or the avoidance of consultant survey or other costs, as well as the avoidance of the financial detriment of needing to comply with the application requirements or going through some other possibly more erroneous permitting process. In doing so, Ms. Jasperson prohibited the city from knowing of and seeking additional consultation or surveying. But for holding her position as a city recorder and exercising her authority to process and approve such permit applications, Sheila Jasperson would not have been able to obtain the fence permit without first having complied with the Type 1 application processes and zoning code requirements. By failing to do so, it appears Ms. Jasperson engaged in a prohibited use of position in violation of ORS 244040 subsection 1. Additionally, Ms. Jasperson was met with an actual conflict of interest in which she needed to declare. In the information gathered, Ms. Jasperson did not submit a written notification of her conflict of interest. By failing to submit a written notification, Sheila Jasperson appears to have violated ORS 244-120 subsection 1 subsection C. Additionally, it should be noted that Commission staff reached out to Ms. Jasperson to offer a settlement agreement in lieu of completing the investigation via a stipulated final order, which proposed a sanction of a letter of education. Ms. Jasperson declined and requested that an investigation report be presented to the Commission. Based on the information received, it appears there is a substantial objective basis that Ms. Jasperson violated the prohibited use of office and conflict of interest statutes. Therefore, the report that is in your meeting books recommends that preliminary findings of one violation of ORS 244040 subsection 1 and one violation of ORS 244.120 subsection 1C and an order that the case be moved to a contested case proceeding or that a negotiated settlement be entered.
And which would likely end in a letter of education.
If the settlement agreement it's offered would be for a letter of education, yes.
Right. All right, commissioners, any questions for Investigator Walker? Okay, seeing none, Ms. Jasperson and Mr. Jasperson, now's your opportunity to respond. Again, we ask that you do be brief, and also Mr. Jasperson, keeping in mind that the recommendation is to move to dismiss, and I don't know if I've ever experienced not following a recommendation to dismiss. So keeping that in mind, probably don't want to talk yourself out of that. And
Yes, sir.
So now's your chance to respond.
Yes, sir. Did you want to go first? I'd just like to say thank you all for giving us an opportunity to at least say one more thing. I appreciate the findings, and in my mind, my military government mind tells me that if the city recorder, whoever that was, did everything correct, in order for me to do everything correct, I feel like that the letter of education needs to be for the city, because guidelines have been followed, as Miss Annie Boyd stated when she was interviewed, which you didn't get to just hear that, but she stated that she's been doing this for 30 years, and every city recorder all the way up, training each other as they go, have approved for family, for friends, because we're a town of 700 and it's a one-person shop. So education, absolutely. For the city council in general, perfect. For an individual trying to do their job correctly, I don't feel that's correct. That's all I have. Thank you for hearing me today.
Thank you, Ms. Jasperson. Yeah.
I guess not to recreate anything and to repeat everything all over again, but I believe, as I stated when we were before you in the past, I followed all the rules that I was that were put before me as the city recorder. I believe I explained to you in the past that we are a one-man show. I don't have anyone else that does that type of work that I could have passed that off to. And as far as the information regarding getting surveys and things like that, I do understand that is in there. That has been pointed out. However, I'm more than welcome to go, more than willing to go back however many years, 20, 30 years, that has never been done in the city of Weston. So I guess I just would say that I feel like I'm, because a citizen has a personal vendetta against me, that I'm being pointed out for not following these rules. That it may be correct that it was in our ordinances to do that, but it has never been done. And I stand behind very firmly that I have a lot of integrity, and I do the right thing at all times, that I do my best. And had I known that I needed to do that, I would have done that. And it was pointed out to me in a previous interview that ignorance was not a defense. And the definition of ignorance is not knowing. It's a lack of knowledge, education, and awareness. And I was ignorant to that. And I did not know that I needed to do that. And I just want you all to know and understand that had I known I was supposed to have done that, I would have done that. And you all don't have the opportunity to go and do audits of my work that I was there for 12 years for. And I continuously had 100% audits with the state, and I pride myself in doing the right thing. So I guess with that said, I apologize, I'm getting a little bit emotional, that I just want you all to know that I intended and will always intend to do the right thing, and tried to put nothing through, and tried to get anything for free or against any ethical anything. So I'm going to stop now and just know that I appreciate you hearing me. And the reason why I wanted to go forward with that was because I didn't want something of a guilty mark on my record for something that I didn't feel that I was guilty for being ignorant of.
Thank you, Ms. Jasperson. We appreciate it. Commissioners, any questions of the Jaspersons that you might have? Seeing none, I'd welcome conversation as to where now's the time to make a decision on whether we move to dismiss or follow the recommendations of staff. So any conversation on that? If not, is anybody strongly prepared to make a motion? And I know that we're talking about 3 items now, but I'm just speaking generally.
I said 4, Mr. Chair.
Well, just the first 2.
Pardon me.
The other ones are.
I understand. Thank you very much. Yeah, 4 issues of the same. Mr. Chair, I'm prepared to make a motion if you want, but if you would rather allow moments for discussion, I'm pleased.
Yeah, I wouldn't mind having a little bit of discussion first. It sounds like no one's really speaking up right now. So I guess I'm always hesitant to go first because I don't want it to direct it in any way. I'm torn on this one. I am. I totally respect the technicality and the efforts and the not knowing. And the likely outcome is a letter of education. Again, the education were there, right? And so for me, making a finding of a violation, which ends up in the letter of education versus making a finding of not a violation, and we're already there. So that's what I'm struggling with and what precedent it has. But that's just my comments, and you're welcome to respond if you want any, commissioners, or not. Yeah.
So, 2 things I would like to say. This situation of approving a person in a city approving a permit for themselves or their relatives, this is precisely the example that the commission has in the public officials guide, saying to people, here is our opinion that if you are in a position at a jurisdiction where you would approve a permit for yourself or relative, you would have a conflict of interest and need to make a written disclosure. Ms. Jasperson is correct that she is a one-woman shop. It's a very small town, so we do understand, but the statutes are set up in a way to accommodate that. Her obligation as a public official is to make the written disclosure. Her city council then could look at it and say, well, we don't have anyone else, so we are directing you to process this in the ordinary fashion. Had that happened, everything would have been according to statute. So I'm a bit concerned about the commission has said in its official opinions in the PO guide that this precise situation is a conflict of interest.
Well said. Thank you. Any other comments, commissioners?
Someone's trying to.
Was that you, Commissioner Burke?
I apologize. That was Jack Jasperson. I realize my time is up and our time is short, but I just wanted to say that I loved her point and she's exactly correct. And if the city council had that in our ordinances and in our rules and our guidelines and our SOPs, that would be amazing. And it's not, unfortunately.
Thank you. I have a feeling that you're gonna make, well, I won't say that, so. All right. I trust that will happen. I'll leave it at that. All right, seeing no comments then, Vice Chair Fiscom, do you have a motion?
I do, Mr. Chair, and I won't make any further preamble this time. I hereby move that the commission find there is a substantial, pardon me, there is a sufficient evidence that Sheila Jasperson has violated ORS 244.040 sub 1 and ORS 244.120 sub 1 sub C, and that the commission adopt the investigation report as its preliminary findings and order that this case be moved to a contested case proceeding or that a negotiated settlement be entered.
And that's on agenda item 35.
That's on agenda item 35. Thank you, Chair.
Thank you. Any comments on the motion before us? Seeing none, we'll call for the vote.
Commissioner Burt,
Aye.
Commissioner Thompson,
Aye.
Commissioner Fiscom,
Aye.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Vice Chair Fiscom, agenda item 36.
Yes, sir. Agenda item 36. I hereby move that the commission find that the complaint and information available during a preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Mr. Jack Jasperson has violated provisions in government ethics law or warrant for the review, and that this complaint be dismissed.
Any comments? Seeing none, we'll call for the vote.
Commissioner Thompson,
Aye.
Commissioner Fiscom,
Aye.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Vice Chair Fiscom, agenda item 37.
So this, we have to have a separate.
Oh, this is
A
the
separate report, I think, right? Yes.
Even though it's my initials, I have reassigned it to Investigator McIntyre.
okay.
Does this report apply to 37 and 38? Or
Yes.
okay, thank you very much.
That's slightly different reports, as
Thank
each individual did different things, but yes.
Thank you.
Thank you.
So thank you, Chair Lindsay and Commission. This is Investigator Andrew McIntyre for the record. Regarding agenda item number 37 and number 38, which are investigatory reports for Sheila Jasperson, who is the city recorder for the city of Weston. And then item number 38 is for Jack Jasperson, former code enforcement officer, city of Weston. Sheila is also the former city recorder. She has just she recently resigned as well. So this case, and Ms. Walker outlined kind of how we got to this in her presentation, so I'm not going to reiterate that. This case has to do with Sheila Jasperson and her husband Jack Jasperson, who are the owners of a coffee ice cream cart business, which is called the Beaver Buzz. And this has to do with them securing a lease with the city to place their business at the city's mini park. And they were able to do that for $100 a month, which included water and utilities. There was kind of two different steps that occurred in order to make this happen. Initially, there was an April 2023 council meeting where placed on the agenda by Sheila in her official position. She physically typed up the agenda for that. Was an action item for Mr. Jasperson to request to the city council in order to place the Beaver Buzz at the mini park for a local event that was going to be coming up called Pioneer Days. During the meeting, Mr. Jasperson requested to them to do that on a temporary basis for that event. That was discussed amongst the council, and it was ultimately approved. Ms. Jasperson did not actually participate in that discussion, but she physically wrote up the agenda where that was placed on, which had the impact. The second instance later occurred on June 14th council meeting. There was nothing on the agenda related to the Beaver Buzz. However, at the meeting, Mr. Jasperson asked the city council, and he did so during public comment, about the opportunity of potentially placing the Beaver Buzz at the mini park on a permanent basis due to the success that they had during Pioneer Days. Mr. Jasperson participated in the discussion as the owner of the Beaver Buzz and not from his official position as the code enforcement officer. Council members and individuals discussed the proposal, including what the Jaspersons might pay. A big part of the discussion had to do with the electrical that needed to be upgraded in order for the Jaspersons to be able to hook up the coffee cart to electrical, so they did not have to run it off of a generator, which was loud and could cause some disturbances. After the council voted to approve Mr. Jasperson's request and to pay a reasonable fee a month in order to place it at the mini park, Ms. Jasperson spoke at the meeting from her official position. She even acknowledged that it wasn't appropriate to do so. And she stated that I wasn't going to talk because it not being appropriate, but at some point electrical will have to be addressed. So at the next meeting, perhaps the proprietors could provide a formal bid from Doyle Electric, and council could make a decision based on that formal bid that is received. So she made a statement at the meeting from her official position that could financially impact the Beaver Buzz. The next council meeting was July 12th, 2023. Ms. Jasperson, once again acting in her official position, typed up the meeting agenda and placed the Beaver Buzz agenda item on it. Do want to note that Mr. Jasperson resigned prior to this meeting from his public official position. Therefore, as of the July 12th meeting, he was no longer a public official. While they were discussing the Beaver Buzz, Ms. Jasperson once again participated in the conversation. She mentioned that the Beaver Buzz did have proper insurance for the business while it was at the mini park. She then later stated that she shouldn't be talking. But after that, when council was discussing that the council should have a contract to look at before approving the Beaver Buzz at the mini park, and council mentioned that they'd already approved it at the previous meeting, but they had put it back on the agenda for the July meeting for transparency reasons. Based on a comment that Ms. Jasperson had requested they do so. She stated at that meeting then that I can't contact the city attorney and ask them to put together a contract for myself as a person of the business. Conflict of interest has to come from someone else. And that prompted the mayor to state he would contact the city attorney and run it by them. So she, in her official position, was talking during the meeting, even acknowledged that perhaps she shouldn't have been doing so. The next council meeting was August 9th, 2023. Once again, Ms. Jasperson physically typed up the agenda. She included an action item of approving a bid for electric at the mini park and also approved the Beaver Buzz lease and contract there as well. There was some discussion during that about cameras. While they were kind of discussing the specifics of the contract itself, Ms. Jasperson piped or spoke up at that time and stated that for the record, Beaver Buzz already installed cameras at our location, essentially attempting to use her position to sway the council to accept the contract. At all times during this time, Ms. Jasperson never provided her appointing authority with a written conflict of interest disclosure, as the law requires. Mr. Jasperson, on his part, he never took any actions, made any decisions that were within his official position. And therefore, the recommendation is to dismiss on Mr. Jasperson's case. And on Ms. Jasperson's case, the preponderance of evidence is that Sheila Jasperson used her position as the city recorder to financially benefit her business, the Beaver Buzz, in violation of ORS 244-040, on 3 occasions, or 1 occasion with 3 equivalent actions, and then also did not disclose any of the associated conflicts of interest in violation of ORS 244-120, subsection 1, subsection 3, with 3 equivalent actions to that as well. So thank you.
Thank you. Any questions for Investigator McIntyre? Seeing none, Ms. Jasperson, would you like to respond?
I'm not sure that there's anything else to add that I didn't make clear in my first case. You already all are aware that I am a one-man show, and I'm not here to rebuttal what the investigator had said. I really don't believe that there's anything. It's appalling to me that it's gone. This has gone where it is. Once again, individual has a personal vendetta, and I would do nothing to not follow the rules. So we don't need to go around in a circle with this. And no, I have nothing further.
Thank you. Mr. Jasperson, do you have anything to add?
Yeah, yes, Mr. Chairman. It's just that we're looking forward to going to the contested hearing. There was so much left out on Mr. McIntyre's investigation. I hope that you all at least get to see that in person. There was already underway prior to us wanting our 6-day-a-month coffee shop at that little mini park under FEMA, and grants already being looked at for electrical and also for cameras, because our mini park has a heritage wall and the young folks in a small town tend to think it's fun to remove those names and those bricks. And when Sheila mentioned that we do have cameras, they're fake, they're mounted on our Beaver Buzz. And we were trying to make the statement that we weren't asking for that. We weren't asking for anything other than what the normal citizen would want. So I just wanted to make sure that that was clear. And that's all I have, sir, and I appreciate y'all.
All right, thank you. Commissioners, any questions for the Jaspersons? Seeing none, Vice Chair Fisk, can you prepare to make motion?
Yes, sir. Item number 37 on our public session agenda. My motion is to move that the commission find there is sufficient evidence that Ms. Sheila Jasperson has violated ORS 244.040 sub 1 and ORS 244.120 sub 1 sub C, and that the case be moved to a contested case proceeding, or that a negotiated settlement be entered.
Commissioners, any comments on the motion before us? Seeing none, we'll call for the roll.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke, Commissioner
Aye.
Burke. Thank you.
Aye.
Commissioner Thompson.
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
All right, Mr. Jasperson, the two matters have been,
We have a
Oh, yeah, 38.
motion.
oh, sorry. Go ahead.
Mr. Chair, with regard to item number 38 on our public session agenda on May 10th, I move that the commission find that the complaint and information available during a preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Mr. Jack Jasperson has violated provisions in the government ethics law or warrant for the review, and that this complaint be dismissed.
Thank you. Seeing no comments, we'll call for the vote.
Commissioner Payne.
Aye.
Commissioner Mason.
Aye.
Commissioner McCauley.
Aye.
Commissioner Burke.
Aye.
Commissioner Thompson.
Aye.
Commissioner Fiscum.
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Thank you. Ms. Jasperson and Mr. Jasperson, thank you for being with us today. The matters against Mr. Jasperson have been dismissed, and then the matters against Ms. Jasperson, as you've duly noted, will proceed to that contested case or stipulated. And thank you for being with us today.
Yes, sir. Thank you.
Punch is here.
Okay, so let's just talk about the rest of the agenda here. We have a lot of stipulated final orders to get through, agenda items 13 through 34, which have a report per.
They do. I have asked everyone to keep them very brief.
Okay. Fact of the matter is, we're going to be approving them. Most likely, I'll put that condition. And so my recommendation is maybe we can take a 10-minute break and then we go through these working lunch.
Yes.
Okay.
Mr. Chair, do we need to consider, or Ms. Myers, 39 as an item for action or not?
It is an active.
Number 39.
Oh,
Okay.
it won't take.
No, thank you very much. Thank you. That's just to be added to your agenda, Mr. Chair. Thank
All
you.
right, we'll meet back here at 12:33. All right, we're back on the record in regular session. Like we have Commissioner Payne, Commissioner McCauley, Commissioner Mason, and Commissioner Burke online. We're now on agenda item 13 of the regular session. So this is a question that I have. Historically, we've had individual reports on stipulated final orders. I'm not aware of an occasion where we have voted no on a stipulated order. That's the purpose of stipulation. And so my question is, or statement, I guess, is if there is no statutory reason or statutory requirement for us to have a report on each of these, can we just proceed without a report on these? What I'd like to do is just vote on each agenda item individually without having a report. If it's just habit and culture that we've done that, then let's scrap that.
I am quickly double checking that we have an administrative rule saying we can do that.
Because I was just telling you about this the other day, because I was like, it says we can do a consent calendar on STIPs. Why don't we do that?
That's my second. So we can do this. I would propose in the future that we move these to the consent calendar, and just like the consent calendar, if we need to remove some, let's do that. But I would recommend, if possible, for future purposes, we move STIPs to the consent calendar.
So,
Sorry to put you on the spot, but
That's a genius.
Well, on the latter,
that on the record. I want that on the record. You said it's genius.
that we vote on each
Oh, on- for
individual,
the-
but we
these-
do not have to do the summaries.
No,
the virtue of
I'm
the
sure that-
consent calendar is that if somebody wanted to pull an item off because it was quote controversial or personal, you could do that just like the consent calendar.
Right.
Which is, I think, to echo what you just said, Chair.
You have an answer?
especially for now, yeah, there's no need for the reports.
Right. Okay, so let's just do that then. We'll forego the reports, but we will hold individual votes on these. And I would like to put on the record, though, that we asked the staff to determine whether we can move STIPs to the consent calendar. That would be wonderful. And we're thankful for today that we have so many STIPs, because I think it forced us to consider the question. So, okay, so that said, we're just gonna plow through these individual votes. And on agenda 13, I'm giving Vice Chair Fiscom a moment to swallow so he can make a motion on agenda item 13.
And we will vote, Mr. Chair, individually on matters pursuant to our councils and chairs and executive advice. Okay. Item number 13. I hereby move that the commission approve the proposed stipulated final order as the final order in this matter, and that the chairperson be authorized to sign it as such.
No comment, please call for the vote.
Commissioner Fiscom,
Aye.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson.
Aye.
Chair Lindsay,
Aye.
motion passed 7-0.
Vice Chair Fiscom, agenda item
Chair.
14.
Number 14, I hereby move that the commission approve the proposed stipulated final order as the final order in this matter, and that the chairperson be authorized to sign it as such.
Call for the vote.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson.
Aye.
Commissioner Fiscom,
Aye.
Chair Lindsay,
Aye.
motion passed 7-0.
Vice Chair Fiscom.
Mr. Chair, at item number 15, I hereby move that the commission approve the proposed stipulated final order as the final order in this matter, and that the chairperson be authorized to sign it as such.
Call for the vote.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Mr. Chair, item 16, I hereby move that the commission approve the proposed stipulated final order as the final order in this matter and that the chairperson be authorized to sign it as such.
The vote.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Mr. Chair, item number 17, I hereby move that the commission approve the proposed stipulated final order as the final order and that the chairperson be authorized to sign it as such.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Aye, Chair Fiscom.
Mr. Chair, item number 18, I hereby move, pardon me.
You're gonna be going for a while, so when you're ready, just tap out and we'll slide that sheet over to Commissioner McIntyre. Thompson. You're up. You did say that I was genius. McIntyre. That's how I got promoted. Yes. So when you're ready, just tap out.
I appreciate it. Mr. Chair, item number 18, I hereby move that the commission approve the proposed stipulated final order as the final order in this matter and that the chairperson be authorized to sign it as such.
Sorry, Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Mr. Chair, item 19, I hereby move that the commission approve the proposed stipulated final order as the final order in this matter and that the chairperson be authorized to sign it as such.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Commissioner Hollis, sorry, Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Mr. Chair, item number 20, I hereby move that the commission approve the proposed stipulated final order as the final order in this matter and the chairperson be authorized to sign it as such.
Commissioner Thompson,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Item 21, Mr. Chair, I hereby move that the commission approve the proposed stipulated final order as the final order in this matter and that the chairperson be authorized to sign it as such.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Commissioner McCullough,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Item 22, Mr. Chair, I hereby move that the commission approve the proposed stipulated final order as the final order in this matter and that the chairperson be authorized to sign it as such.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Fiscum,
Aye.
Chair Lindsay.
Aye.
Motion
Motion.
passed 7-0.
They gave me this nice fancy little book.
Might as well use it.
Exactly.
If you need a copy, let me know.
That's the wrong little nice little book. That I'm not prepared.
Item 23, Mr.
23.
Chair Thompson.
I hereby move that the commission on item number 23, I hereby move that the commission approve the proposed stipulated final order as the final order in this matter, and the chairperson be authorized to sign it as such.
Commissioner Mason, Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Item number 24, I hereby move that the commission approve the proposed stipulated final order as the final order in this matter, and the chairperson be authorized to sign it as such.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Item number 25, I hereby move that the commission approve the proposed stipulated final order as the final order in this matter, and the chairperson be authorized to sign it as such.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Item number 26, I hereby move the commission approve the proposed stipulated final order as the final order in this matter, and the chairperson be authorized to sign it as such.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson.
Aye.
Fiscum.
Aye.
Commissioner Payne.
Aye.
Commissioner Mason.
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Item number 27, I hereby move the commission approve the proposed stipulated final order as the final order in this matter, and the chairperson be authorized to sign it as such.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Commissioner Mason.
Aye.
Commissioner McCauley.
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Item number 28, I hereby move the commission approve the proposed stipulated final order as the final order in this matter, and the chairperson be authorized to sign it as such.
Commissioner Thompson,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Commissioner Mason.
Mr. Mason?
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Item number 29, I hereby move the commission approve the proposed stipulated final order as the final order in this matter, and the chairperson be authorized to sign it as such.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Item number 30, I hereby move the commission approve the proposed stipulated final order as the final order in this matter, and that the chairperson be authorized to sign it as such.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Fiscum,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Item number 31, I hereby move the commission approve the proposed stipulated final order as the final order in this matter, and the chairperson be authorized to sign it as such.
Mr. Chair, just a quick comment for the record before the vote. Mr. Rose and I have been acquainted for too many years to count. Robert Rose, better known as Ozzy, is a longtime lobbyist at the state capitol. I don't need to declare that as a conflict that would prevent me from voting when the moment arrives. But for the record, out of an abundance of caution, I feel better citing my relationship in the past with Mr. Rose. Thank you.
Thank you.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Item number 32, I hereby move that the commission approve the proposed stipulated final order as the final order in this matter, and the chairperson be authorized to sign it as such.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Item number 33, I hereby move the commission approve the proposed stipulated final order as the final order in this matter, and that the chairperson be authorized to sign it as such.
Commissioner Mason.
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Finally, agenda item number 34, I hereby move the commission approve the proposed stipulated final order as the final order in this matter, and that the chairperson be authorized to sign it as such.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
All right. Well, thank you. And do we have an answer on did I see you look at it?
We'll continue to look at that.
Okay. All right, but you're very welcome, investigators, for avoiding the summaries, so.
There are, we got rid of a lot of cases just there.
All right.
We do need to go back to items 11 and 12.
Oh.
The consent.
Oh, I see.
Yeah.
I see.
Say it in there.
Oh,
All right.
very brief.
Director Myers, agenda item 11.
Yes, this is a recommendation that Hans Bernard, this is technically his 9th late filing violation as a lobbyist. He's always paid in the past. The recommendation is a letter of ed and reduce his penalty of $22.50 down to $225.
Mr. Chair.
Why the reduction? 9th time?
He has not requested mitigation or a waiver previously, so he simply, usually he was late by like a couple days. This time there was a longer penalty, a longer period. And his email, I don't go and look at his email, but I think he explained why.
Mr. Chair, that happens to be my first question too. Mr. Bernard is a well-known individual in Oregon. I will cite that for the record as well as I did previously. I have known him for a long time, no personal acquaintance in a friendship at the moment, but he's been around for a long time. He obviously now, according to the record, works for Nike, and he knows about these rules and regulations. For there to be 9 violations strikes me as a pretty significant number. If there has been a recommendation to go to 225, I'm probably okay with that, but I just want to say for the record that it might be, it perhaps could be more than that, but argue with me, please.
I would point out his explanation was, in the past, as I said, the violations were just 1 or 2 days and he promptly paid those penalties. This time he explains he was on an unplanned emergency medical leave
Sick leave,
and
yeah.
did not have access to his computer.
Yeah, I guess I see the lower amounts pay $30, $40, $20. There's multiple instances, but they're always corrected. This time it wasn't corrected too quickly because of medical leave, so. All right, I'm personally good with the 225, but it strikes me that this is happening a lot. Wouldn't happen if you put it.
Mr. Chair, unless my colleagues have any comments, I will hereby move that the commission accept the staff recommendation to reduce the penalty for Mr. Hans Bernard to $225 for his $225 for his 9th violation. Is that an adequate motion, Madam Executive? Thank you.
See no comments. We'll call for the vote.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
And item 12.
So, and this is my fault in a way. This would ordinarily have been on the consent calendar. I pulled it off the consent calendar. Mike Wamplin is one of the 3 school board members who never filed their 2023 SEI. And I've been in the process of proceeding to default, got the $5,000, reached the limit. So I was in the process of doing default orders for all of them. When Stephanie Hefner here managed to contact Mr. Wamplin, get him to file his 24 SEI and get him to file his 23 SEI. So
Just good timing and also help from the school district staff.
So I simply wanted to call to your attention that now we're only down to 2 people who never filed from school board members.
Right.
And the recommendation would be to waive the $5,000 for a letter.
Mr. Chair, hearing the explanations and seeing no other comments from my colleagues, I hereby move to accept the staff recommendation for a letter of education for Mr. Mike Wantland relative to SEI issues. Thank you.
Call for the vote.
Commissioner Thompson,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
All right, we're done with that. We'll go to agenda item 39. Is that correct?
That's correct. Chair. John Jones at the City of Portland Revenue Division sent in a request for a commission advisory opinion. The memo in your book is my recommendation that the commission deny the request and not issue an opinion. Basically, the issue is that they've identified a problem in that when they hold taxpayer appeals, they are holding them in executive session, but the media has to be present. If the media is present, they're violating the taxpayer confidentiality statutes. They wanted us to solve the conflict of law issue for them.
Yeah.
We can't do that. So I am recommending that you deny the request, but I will and have reached out to them and will continue working with them on whether the judicial exception to public meetings law applies such that it would solve their problem.
There you go. Right. Thank you, Chair Friedman.
Mr. Chair, I will move that the commission endorse the staff recommendation to deny the request for a commission advisory opinion, from Mr. Don Jones from the City of Portland.
We'll call for the vote.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Agenda item 40, is that you, Susan?
These are all simply advisory, a staff advisory opinion, and then letters of advice, informational.
Something a lot of people go to Denmark, is what it sounds like.
So it's number 51, Mr.
It's
Chair.
allowed. Item 51 does need a motion.
Okay. Which one is this? Note to suspend. Oh, yes.
That's on the younger case.
Yeah, it's, investigator Andrew McIntyre here for the record. Item number 51 in your meeting book is a motion to suspend. This case was moved to investigation earlier today during the commission's executive session. As the memo indicates, there is a pending criminal investigation of the respondent, and the criminal investigation relates to the same facts and conduct at issue before the commission. So asking to suspend case number 24052 EHM pursuant to ORS 244260 subsection 6C big A until the criminal matter is concluded.
Thank you.
Mr. Chair, I will hereby move that the commission suspend the investigative phase of case number 24-052, capital letters EHM pursuant to ORS 244.260 sub 6 sub C sub big A. Thank you.
Sounds funny.
Meant to be funny.
All right, thank you. No comments? We'll call for the vote.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
All right, folks, we're now to the all-important trainers report. Oh, here we go.
Good afternoon, Chair Lindsay. Good
What's your
afternoon,
name?
Commissioners. My name's Charlie. As far as I'm a trainer
Thank you very much.
with the Oregon Government Ethics Commission, and this is the trainers report. Coming off the SEI season was really, really busy for us. We were able to pin down 9 in-person trainings, so hats off for us on that one. We did train a lot of jurisdictional contacts, 146 total. SEI filers that stepped in for trainings, 101. We did 20 total trainings this season for SEI filers.
When you say season, are you talking April 15 to
April 15th to March 15th for the SEI filers. For the JC folks, that goes back to February.
Okay.
And we did create a new YouTube video for the new updates for the new SEI this year. That went up and we had 52 unique viewers for that. So that's a big number for us. We're still at it. We're busy in May and we are busy in June. We're going out to John Day, Shanico. Hey, I'm from Texas, so I'm gonna mess that up. So Brookings, Curry County, I'm heading south for that. Drain and Oak Ridge. Yeah, we're gonna keep it up. It's gonna be a busy time for us.
What's the turnout like when you go out there? Usually on the field trips, what's the turnout like?
Well, so far I had 2 of mine shot down. So you have to refer to Lex and Ruth. They came in yesterday and I haven't been able to touch base with them. I know
We
what.
recently went, we had one at Central Point. We had about 30 there. We had one they had Central Point, Rogue River, and also Shady Cove members from there. We also had Jackson County. We had about 25 members, Butte Falls and City of Ashland as well, which had about 10 to 15 10 for there.
And Butte Falls had about 8, I think.
Yeah, Butte Falls. So we try to, depending on whether they open it up to other cities or it's just their city council, but we try to do outreach to open up to as many cities as possible when we do visit. So.
Okay.
Me and Ruth hit Mount Hood Community College. There was about 40 folks there.
Oh, and we did Clackamas County that had almost 50 on a Monday morning. So it was pretty impressive.
And how long is the training?
2 hours.
Mhm.
2 hours and change with all the questions.
Okay.
But that's all I have.
And I do want to just highlight that this morning, Ruth was highlighted in an article for the Ashland newspaper for doing the training in Ashland. And we have had members from the city of Ashland appear before us not that long ago. So that's great that we are getting out there and getting
Excellent.
that recognition.
Excellent.
So I will make sure that that article is in the next book so that you all have it.
Right, Commissioner Thompson.
Vista wants to know which of these trainings coming up are going to be near golf courses. So
You can put in a training request. Gladly meet you out on the golf.
I will do that. You could bet on it.
Long.
caddy.
I'll just follow along next to
You
you.
know how many golf courses there are in Oregon? 200, and we're going to every one of them.
Unfortunately, I can't play, so
Carry my clubs.
keep that off the record.
Set that up.
But that's all I got. Thank you.
All right.
for your time.
Thank you. Director Myers.
So
Hold on, Mr. Sheriff.
Oh.
Mr. Chair, I'm sorry to interject.
Go ahead.
I do have one thing. I have one thing to report on training. I've been asked to speak next Wednesday at a meeting of the Lake Oswego Republican Women's Group, and they have asked me to, spend 15 minutes talking generally about what the Oregon Ethics Commission does. And so, unless there is any reason for me not to, what I'm going to do is, give them the basic 30,000 foot high list of what it is we do, but encourage them to ask for a training from our training people. And so that was my plan. I wanted to see if there was any objection to doing that before proceeding.
No objection. All right, thank you. Director Myers, in her third month,
January.
feels like 12 years.
It's been a very busy 4 months. So The budget number that is in the report is off because this was based as the number at the end of February. Right now, the surplus is approximately $595,000, but that includes the SAL pot, which is the extra money that the legislature awarded everyone to pay for all the COLAs and everything. So I would estimate it's between 1 and 200,000 at this point. We did submit our POPs and our legislative concepts. They were due at the end of April. The POPs basically will ask the legislature for additional funding to pay for our DOJ fees because they're very, very high. Yes.
Yourself.
Spendy. We have asked, we're in the process of seeking to reclassify Becky's position. She basically has been working out of class on the job duties compared to where the original position is. We want to provide some additional funding to the training program, buy some additional hardware and software, and then a little money to pay for additional CMS, EFS upgrades. The legislative concepts that we put forward include the motion in technical fixes, expand the motion to expand an investigation from 30 to 60 days because 30 days never works. We don't have meetings every month. Fix the SEI business language. What that is to correct that confusion in the SEI question 1A and 1B. 1A applies to director or officer of a corporation, and 1B is a member of an LLC, and everyone else. We simply want to fix that, have member and LLCs be in 1A. 1A is the businesses that you are in, and then 1B could be, are you self-employed or something else? We did make the recommendation, the LC proposal to eliminate preliminary review and then just increase the period for investigation. That was one of the.
I thought that would turn down.
It was not turned down. It was frowned upon.
Pardon me, Mr. Chair.
So put it forward. It was a
The
committee.
difference in that language is what? It sounds like there's no difference.
They gave us a yellow light, which meant proceed with caution, whereas two of them, we were given a green light, which was go forth, and then yellow, proceed with caution. None were given the red light, which meant stop.
All kidding aside, that idea came from, among others, me. And what I would say is that if it's a failed errand, you don't need to do it because I asked you to do it. I think there's a rationale for it, but at the same time, if the governor's office is frowning on it, that's what governor's offices do. They either concur or not concur. And if the Governor Kotek office has not concurred, my reaction is so be it.
Yeah, I mean.
Thank you.
And then the last two were the ones left over from the last time, which also came up yellow. And that was adding household member to conflict of interest and cleaning up the gift clause to delete the provisions that have been found unconstitutional. So we are currently undergoing rulemaking for public meetings law. It will be a slow and difficult process, but we are getting it done. We have our first rulemaking advisory committee meeting on Monday afternoon. Additional ones basically every week. Since January 1st, and this number is wrong, at the time I wrote this up a week ago, we have received 181 complaints, opened 77 cases in the first 4.5 months. Opened a few more cases since last week. Sorry about that.
Where are we at historically?
We're up.
We're more than half.
We're about half where we were last year, but we haven't hit 6 months.
Election year?
Yeah. and public meetings law. I mean, we're starting to get those, and that messes with the numbers because like executive session cases, it's 6 or 8 or 9 people all at once.
Yeah. Okay.
And there's also on public meetings, a procedure to follow before it comes to us officially, which
But we
contributes,
still have
contribute to
Put
the.
them in for the
Yeah,
consent
no, I
agenda, so we
understand,
have
yeah,
to open
thank
it.
you.
I've added this update and only because I know that some of the commissioners have asked for status updates on certain cases, so I'm letting you know. On the 6 OLCC cases, we suspended those because they're pending criminal investigations at DOJ. Those are still ongoing, so the cases are still in suspension. On the Fagan cases, we time waived them in agreement with her counsel. We didn't do it as a suspension because the FBI criminal investigation's ongoing. It's a little more difficult to get information on the status of that from the feds. So this gives us the flexibility to work with her counsel when we get information that maybe the FBI thing is, that we might be able to get information from her in the case, that we can lift the waiver and proceed. And then Morrow cases, we had time waived them in order to negotiate stipulated final orders. I think my language here might have been slightly aspirational. I do think we have worked very hard with their counsel and they've been very cooperative. I think we are very close to an agreement. I need to get another draft back to them, just sort of fine tuning the last of the language. So hopefully at the June meeting, we will have a signed agreement, be able to present it to you. Other information, the lobbyists for the first quarter, we are down, thanks to the efforts of our administrative staff, we are down to only 1 lobbyist and 1 client that have not filed. The 2024 SEI season, we are down to, at the beginning of this morning's meeting, we were down to 47 non-filers, and I suspect it might be less than that even now. Because Jessica and David call people all the time. Staffing, our new curriculum enforcement coordinator, Casey Fenstermaker, will be beginning next week. She's been moving here from Pennsylvania.
He's not the curriculum.
Yeah, that is correct. Compliance. Susan was tired when she wrote her report.
She combined our titles. Okay.
Casey begins next week. I'm very much looking forward to that. We have just finished the interviews for the Hillary's replacement, the investigator 3. I still need to go through and score the writing, so hopefully we will fill that position as well. May legislative days at the end of the month. We do have a candidate to replace Amber. It is Ivan Resendez Gutierrez. He's an attorney at Miller Nash. So he would begin on July 1. Last points. I nominated Stephanie and she received the Governor's Public Service Ambassador Award. Well-deserved. He is an excellent ambassador. Then next week, we will be receiving a visit from a group from Thailand. From Laos, who are public officials wanting to learn more about government ethics. It is similar to a presentation we did for them about 4 or 5 years ago. So they will be visiting and we will have a short training.
And it was the guy from Laos that won Powerball.
He did win a lot of money.
Yeah. Did these people have English? Not to be critical, they don't.
They do not. So they
Interpreter?
speak Lao and Thai. They will have 2 interpreters traveling with them as well.
Okay,
So,
yeah,
and there will be 7 or 8 delegates, I believe.
that's good. Yeah.
And Stephanie did live there in Thailand.
Yeah.
Number of.
So I can speak like 4 words now. And more than 10 years ago.
Welcome then, that's all you got to do.
Exactly.
And as far as I know, that is it.
Well done.
Mr. Chair, thank you.
Well before 2.
Yes, very, yeah, great. Well, thank you all. This now concludes the meeting today. I'm going to end it with a slight one. We're adjourned. Thank you.
Thanks, Susan.
Bye, everybody. Have a great week.
Bye.
Take
Good to
care,
see you.
everyone.
Hey, Chef.
Have a good spring.
Are the reasons we